Uh, am I audible?
Yeah, you're from which
A very
school?
good afternoon, Presidency School of Law.
Okay.
A very good afternoon to all the dignitaries and all my learned friends who assembled here today for this consultation. My name is Ashasya Arora, and I'm from Presidency School of Law, Bangalore, and I'm here to make some quick submissions to the Department of Justice for their consideration for the Vision India 2047. So the goal of this little meeting that we've gathered here today is to envision what would India look like, or what would the specific judicial domain of India look like in the year 2047. And I think for the most part, India uh, uh, has had its shares of ups and downs throughout the judicial reforms that have gone by over the years. But some small submissions that I'd like to make for the year 2047, when India will celebrate the century of its independence. One of the first reforms would be the enhancement and reinforcement of alternate dispute resolution. Now, herein, as law students, we learn in law school about ADR, alternate dispute resolution, which consists of negotiation methods like arbitration, conciliation, mediation. The thing about it is the whole purpose why ADR exists is as a out of court resolution method is to alleviate the burden on the actual courts. And I think India has a long way to go in terms of being a global hub for arbitration. This has also been proved by India's regular subscription and the retainment of the first place of the Singapore International Arbitration Center, or SIAC as we call it. As of 2020, India has been the highest subscriber of SIAC out of the 690 countries which usually serve as the clientele for SIAC. So reinforcement of the alternate dispute resolution system would be uh, a critical reform which would be requisite for the efficient justice delivery system, because if all parties concerned are getting a reward out of it, it would serve as a beneficial as a boost to the justice delivery system, and more focus can be laid on the specific matters which are to be catered to by the courts. Another one of my submissions would be for affordable legal aid. A lot of the free legal aid provided in India is lackluster and uh, does not possess the fortitude to actually be able to represent the people who are in need of aid from the subordinate courts, whose matters are pending in subordinate courts. These are people who are not able to afford the best of legal services available to the wider strata in India. So, affordable legal aid not only should be affordable, but should also be made credible, and uh, like more effort and more value should be put into that, into providing that legal aid, so that an efficient, timely delivery of justice can be implemented. And my last submission would be for gender representation. Now, to connect the dots here, gender representation in the judiciary is a very crucial issue which needs to be addressed. As of 2022, only 7.4% of the total judge strength in India is women, and I think this should the Department of Justice, along with the courts of India, maybe can take this initiative to make the judiciary a lucrative and incentivized place for women to apply and rise high in the judicial ranks, which will also serve and pave way for a wider demographic and a different strata from the Indian society to be included in the judiciary. As we have seen, it cannot just be limited to women. Ms. Joyita Mundal, who has broken precedents of the past of India since India's conception, and becoming the first transgender judge of the country.
directors and fellow participants. So I would like to start the suggestions and the consultation with furthering on the points just in the last consultation. Additional secretary and joint secretaries and secretaries just mentioned about that how we should also empower our public prosecutors and the investigation agencies, as SLS Pune has just mentioned. Like I hail from the state of Himachal, and in the state of Himachal, under the prosecution manual, there is a process of scrutiny before any IO or the police department put in any case into the court, so that before they can put those cases in there, because sometimes what happens is the IOs, which we have usually the head constables or at max the ASIs in normal cases, until unless it is of a very severe nature. So if we put the scrutiny process in there, what we get is a better conviction rate and more advocacy. As the public prosecutor is the better person to tell the IOs which charges can go up, which charges shall go in the file, because at the end of the day, the prosecutors have to fight it in the court of law. My another suggestion would be, as Honorable Prime Minister said, and I quote, that we must understand judicial reform is not merely a policy matter, but a human sensitivity should be considered at the time of making any deliberations. It was said in the reference of using local languages in the court, so that the administration of the justice can be moved swiftly, and all the stakeholders can understand what exactly is going on, as language can shall not be the barrier for in the delivery of the justice. Another thing, as digital courts are digital courts are inevitable, we have to in a coming time accept the reality that we are all shifting towards the digitization, whereas how we can perform the digital courts is we can use the digitalization as the linkage of annexes. That means that when we have to call for the expert opinions and advices, we do not have to call the officers and the interested parties directly to the court to being produced as a witness, where we can provide them digital support so that they can take all the meetings online only, so that it will also reduce the cost of all the travels that the government has to bear in the end of the day. And further, I would be saying that we need the specialized codes for the specified domains. Just mentioning as that we need specific codes for the section of IPR, because although all the judges, honorable judges, are very competent, but still we cannot
Kindly
simply put all.
conclude your point.
Sure, ma'am. So I would just say that we would still need to sorry. We would need to skill advancement of all the judicial officers and the stakeholders, and we would need to provide better training and better infrastructure. And that is all. And thank you.